Okay, we're live.
Good afternoon. It's April the 1st, 2021. This is the House Judiciary Committee, and we're hearing a number of Senate bills today. We're going to start with Senate Bill 497 and the chair of the Finance Committee in the Senate, Senator Kelly. This is the bill related to the school system at DJS. Chair Kelly, would you like to present? Let me see. Do you have anybody else? It's just you. All of these are sponsored hearings, if I'm not mistaken. So, Chair Kelly, go right ahead.
Thank you so much, Mr. Chairman and members. For 7 years, I've been going down this path trying to see what we could do to make a better school system for kids who already have been remanded to the Department of Juvenile Justice. So I'm here today regarding Senate Bill 497. I want you to know there are a lot of people in Maryland, including Judge Barbera, who I have met at conferences in other states, all seeking to see what we could do to better this situation. Given that the Maryland State Department of Education operates no county or other school system except for Maryland's Juvenile Services Education System, and given the lack of an independent school board focusing on the unique educational, psychosocial, and other special needs of students who are in custody of the Department of Juvenile Services, there is a critical need for the creation of a separate school board and school system adapted to the unique needs of these kids. We can't consider them as throwaway kids. We have to help them to get the skills that they need, to get the healing that they need, and to become taxpayers and persons of whom we all can be proud. As introduced in the Senate, this bill was intended to improve equity and opportunity for the largely low-income and predominantly minority youth who are committed to the department. We need them to become high school and college graduates. We need them to be civic-minded. Their needs are great, and they cannot be educated without an adequate system run by an appointed school board of dedicated professionals, such as the proposed bill that we have before you today would create. I won't go into detail because you can see the bill and what was originally recommended, and I know that the bill was sent secondarily to Ways and Means, and they've also added some amendments in order to make certain refinements in the nature of the school board, but we all are agreed we need a special school board committed to these kids. And we need one that will insist that as they disenroll because they're going into custody from their community schools, that they aren't for a while in no school until they get a placement in one of our juvenile justice placements. And then after having been disconnected from the community school with no coordination between the two school systems, that they end up somewhere else. I'm not going to read from my testimony altogether, because I'd like to just say that what I have found over the years working on this issue is not only the problem that when the kids come into the system, they are already disenrolled from their community schools. There's no discussion, no passing of documentation to show what experiences the kids have had educationally, what subjects they have mastered, if any, or any special needs that they have. There just is no connection right now. And that's one of the things that this bill is intended to fix. Also, when they leave the system, the juvenile justice system, they need help to get them back enrolled and in an appropriate setting with the right objectives as they go back to a community school. That is, if they even get back into the community school, because we offer no help. There's just no coordination between the two systems right now.
Madam Chair, if I could ask you to begin to wrap up, I'd appreciate it.
Sure. And so since I know you guys know the bill, what I say is that I've seen the amendments that the secondary committee has recommended. I'm okay with them. I think it makes a good bill better, and ask for your favorable vote on Senate Bill 497 as amended.
Thank you very much. Delegate McComas with a question.
Thank you.
Mr. Chair,
Chairman Kelly, I appreciate all your good work over the years on this issue. My question to you is basically, do you feel that if we have what I would call a specialized school board here that's going to monitor and basically be able to give recommendations to dealing with this group of children that really need specialized help, more professional help dealing with kids that are in the system and have all these problems. Do you think that that's going to really help them basically, what do I want to see, do well academically and get them on the right path?
Absolutely, I do. And then in addition, this bill would create better resources for the education of these kids than what they have right now. Right now, we're spending less for teachers 12 months a year than other school systems get for 9 months a year. And there's a lot of coming and going in terms of who the staff is, a lot of absenteeism because people are demoralized and they know they're not well resourced. And so, yes, everything would be better.
And do you also foresee possibly, what do I want to say, call like teachers' aides that basically are going to make sure that there is that kind of continuity in the sense that instead of just maybe mailing the stuff to the school, it actually, that when they get back out of the system, that it's literally walked over to the school. And in other words, a lot of connectivity that's.
Yes. And then one thing about it is this bill requires their monthly school board meetings open to the public, and that the Juvenile Justice Monitor will also monitor those meetings, that you and I can come and testify and find out what is going on. Yes.
Does the Juvenile Justice Monitor now not be able to go to the Board of Ed meetings about
Well,
that?
they don't really have the schedule
Gotcha.
on a regular basis, right?
Okay. All right. Well, thank you.
A lot more transparency.
Thank you very much.
Thank you.
Thank you very much. Madam Chair, Delegate Cham has a question.
Sure.
More of a comment. Thank you, Chair. Hi, Chairman Kelly. I'm one of
How are you?
your delegates. How are you? Nice to meet you. I really just want to applaud you on this wonderful piece of legislation that you're bringing forth. I was one of those 12-month non-public teachers working with the really challenged youth, not students who are part of the juvenile justice system, but students with really challenging behaviors through autism. So certainly working in those non-public programs, 12 months a year, you really don't get those pats on the back like a typical public school teacher does. We need a lot of resources, a lot more support for the youngsters that we work with. So hopefully this bill will work closely and help our youth stay on track and provide them with the resources that they need and the staff to help them. So thank you.
Sure. We're glad to have champions like you who know what the needs are.
Thank you.
All right. Thank you very much. Are there further questions for the chair? Seeing none, we thank you very much. That concludes the testimony on Senate Bill 497. Thank you very much.
Thank you very much.
All right. Now we'll go to the senator from the 45th district, Senator McCray, who is here with two pieces of legislation. We're going to start with 114. There are two other people who are here to testify, J. Wendell Gordon and Terrence Bradley, who are signed up to testify. Senator McCray, if you'd like to go ahead for 3 minutes, that would be fine.
Thank you, Mr. Chair. Thank you, Madam Vice Chair, and thank you, members of the committee. First, I'm just excited. I didn't know my friend J. Wendell Gordon was going to be joining me, but always excited when the warrior lawyer can join me. Mr. Chair, this is the easy bill. We did a significant amount of work around the Justice for Reinvestment Act, and a part of the Justice for Reinvestment Act back in 2015-16 when we did it was around expungements. Unfortunately, there were some things that's left off. I think that this is a bipartisan opportunity. It was a bipartisan opportunity in the Senate that was worked on. My friend, my constituent, my colleague, Terrence Bradley is an electrician. Unfortunately, Terrence had action when he was in his early 20s that he's still paying for till this day. So 20, 30 years ago, he made decisions and he's still paying for those decisions. when you are in the state of Maryland and you drive on a suspended license and you commit a misdemeanor, this is a non-expungible offense when you do them simultaneously. We are coming to correct that action. And as stated, this affected Terrence. I'll let him tell his own story, but he works for an electrical contractor, has moved his way up for the electrical contractor, was as a quality control that is very significant in my industry. So that's not just doing the electric work. You're actually watching everyone else do it and make sure that they do it in the proper manner. But working on government sites, this was still impeding him from being able to do that, Mr. Chair. I will not belabor the committee anymore. I think that they understand where I'm trying to go with it. But I hope for the successful passage of Senate Bill 114. And thank you all for the opportunity to share.
All right, thank you very much. I was wrong before when I said that Mr. Gordon, the warrior lawyer, as you put it, said he is going to be here. Apparently, he is not in the waiting room. We apologize very much for that. Got everyone excited. All right, but Mr. Bradley is here, so let's hear from him for 3 minutes.
Yes, sir. And ladies, thank you. I have overcome some obstacles in my life. However, my past still haunts me until this day. In 2017, my ability to access Fort Detrick, which I had since 2007, was revoked. And after questioning security, I was told that the background eligibility requirements had changed on the base. And because of my criminal record, I was no longer permitted to work there. So the security officer expressed that I needed to have the charges expunged before I could return. In 2018, after requesting and receiving a hearing in the expungement court, the judge who expressed her desire, yet inability to help, suggested that I contact my local representative for assistance in clearing my record. And in another chance meeting, then delegate, now Senator McCray and fellow electrician, after hearing my story, he'd offered to help. So today I'm asking you to allow me to expunge this conviction, driving on motor vehicle while license was suspended. For this expungement, I'll be able to remove all the other null process charges that would involve with this same charge. And it's been on my record since 1996. And yes, I've broken the law, but I've endured, I've given back to the community. I changed my life. I acquired additional education and meaningful employment. And I'm a proud member of my family, society, residing in Baltimore County. And now after purchasing my first home in 2017, nevertheless, this event, which took over 25 years ago, is still continued to negatively impact my life. So thank you.
All right, thank you very much. We'll go to questions and very quickly. Senator McCray, so this also says that it makes, I think, a slight alteration to driving suspended H violation. H violation being you were suspended for the failure to pay another fine. So it basically says that you've still got to appear in court for that, and you can't prepay the $500 fine. Okay,
Exactly.
I've got that. So this is just all the 16303 Cs would be able to be expunged as anything else on the expungement list.
Exactly.
Okay. Are there questions for Senator McCray? All right, and that's fine. Certainly thank Mr. Bradley for being here today and sharing his story. And that concludes the testimony for Senate Bill 114. We're now going to go to Senate Bill, which requires me to have a different folder, 914. Senate 914 is Senator McCray's bill as well. This has to do with the Baltimore City Sheriff's Office, and I think I saw Sam Cogan, Frank Boston, and Josephine Zillman Georgie, I think. There you are. That's fine. So Senator McCray, if you'd like to start for 3 minutes.
Thank you, Mr. Chair. I won't speak too long on it because I know we have a number of witnesses. But for the record, Corey McCray, Senator for the 45th Legislative District, always thankful to be with JPR. Yesterday, I didn't start off by saying—
Wait. What?
Judiciary. I'll say it twice. Judiciary.
Quite. Yes, that's fine. That's good. Start. You're good now.
Yesterday, I did not hone in on the point that this is a local bill. This bill was unanimously voted out of our local delegation, which just gives our sheriffs the basic right to collectively bargain for a portion of their collectively bargain for their working conditions. I'll let Frank Boston, Sam Kogan, and Miss oh my God, help me out, Frank.
Josephine Zellman.
Miss Joe. Yeah, I couldn't get it out my mouth. Just go into why this is important for our deputy sheriffs with the sheriff's office. Thank you, Mr. Chair.
Let's hear from Sam Kogan.
Good afternoon, everyone. Good afternoon, Chair and Vice Chair and the committee. And I want to thank the sponsor for this bill. So this is a bill that would allow the sheriff's deputies to do collective bargaining as opposed to the salaries right now for the sheriff's office are codified. And in order for them to get a raise, they would have to come in front of this body and request legislation. Management is very much for this pro-labor bill because it will allow them to meet with the city labor commissioner and negotiate like other sheriff's offices and other city agencies would be able to do. And so for that reason, we are in support of this. And like I said, this is a coalition of the city being in support of it, the management being supportive of it, and the union being support. So we are in support of 914, and we would urge your favorable support.
Thank you very much. We'll go with, as Senator McCrae's put it, Miss Joe, Josephine Zillman Georgie, and then we'll hear from Frank Boston.
Sure.
Did we lose her?
Yep. You might.
Oh dear, we lost her.
No, she's there. There she is.
Okay, can you see me?
Yeah, go ahead.
Okay, I'm sorry, sir. Good afternoon. Thank you very much for your time. I am the president of Lodge 22, and I represent the men and women of the Baltimore City Sheriff Office, and we would like you to vote in favor of our bill 914, collective bargaining for the Sheriff Office. This will allow us to sit down and help have some input in the decisions that are made, which governs our deputies that go out on the street and do all the work that we need to do for the city. Also, it would also give us a voice in the process of negotiations with our management in helping our working conditions, our benefits, salaries, uniforms, and equipment, and other things. We would like you to vote in favor of our bill, and I thank you for the opportunity and time to express that to you.
Thank you very much. Let's hear from Frank Boston briefly and go from there.
Yes, sir. Good afternoon, Mr. Chairman, members of the committee. I'm Frank Boston. I'm the legislative attorney for the State Fraternal Order of Police. We support this bill. I'm not going to repeat what's been said, but the committee should know that both the city, Senate, and House delegations support this bill. Department of Budget and Management supports this bill. FOP, the city of Baltimore, the management from the Sheriff's Department, as well as us, as I already said. So everyone's on board. We took time last year and worked things out, and want to give special thanks to Senator McCrae for organizing in our efforts. And we ask for a favor.
Are there questions for this panel? Seeing Delegate Cox.
Thank you, Mr. Chair, and thank you, Senator McCrae and panelists. Real quickly, I had a couple questions about the sheriff's office. What is the statutory salary and then the duties of the sheriff, constitutionally elected sheriff in Baltimore City?
Sam?
So I can take that. So the salaries are codified in courts and judicial proceedings under 2. It used to be 309. I know that changed. I don't know which one it is. And it says a deputy sheriff shall make no less than a state employee as a grade 14. And so that's been very problematic because that's not a law enforcement scale. And we would, every time we need a raise, we have to come back and get legislative approval for that. So it would be much better to be able to negotiate that than rather to come back. And the statutory duties are, we have the courthouse security, we have the warrant service, sort of the enforcement of the courts, the evictions and foreclosures. We took over the domestic violence from the police department, so we serve all the protective orders and the peace orders in the city that originate out of the circuit court and the district court. We have people on fugitive task forces with the United States Marshal Service and task force officers with ATF and DEA. I know I'm forgetting something, but those are our basic duties quickly.
And also, Delegate Cox, this is basic collective bargaining. It's not binding.
Right. No, that's great. And so what is the salary amount? I didn't catch it for the sheriff and then the deputy sheriff.
For the actual sheriff or for the deputy sheriff?
Yeah, but yes, both. The salary, the actual salary amount right now, the annual salary.
I don't have that in front of me. I can pull that up for under courts and judicial proceedings and try to send that to you. But it's under 2-309. The sheriff's deputies, I think it starts at 36,500, and then it goes up to, I think it's in the like mid 60s for the deputy sheriffs, off the top of my head. But it is in there.
So these are people that put their lives on the line and they're only starting out at $36,000. That really bothers me, but thank you so much. As a follow-up to that, how many do you have on the force?
So it's 103 deputies are codified, and that's also codified. And then we have about 70 court security positions that are also sworn.
And historically, has the sheriff always been limited to those areas you mentioned?
In the city, yes.
In the city.
Yeah, so the city, we're actually the youngest sheriff's office because we were formed by constitutional amendment in the shortly before the Civil War, when the city ratified, so they would have their own sheriff's office and you wouldn't have to have the county come in. But we've basically been the enforcement arm of the court, but we also have full law enforcement authority as well.
Thanks so much. Appreciate it.
Thank you. I think I don't think I see any further questions. I don't. That concludes the testimony on Senate Bill 914. Thank you, Senator McCray.
Thank you.
All right, thank you. We're going to go now to Senator Waldstreicher, the Vice Chair of Judicial Proceedings. It's Senate Bill 78, and it's just him. Okay, Senator Waldstreicher.
I see how I get out of here.
Just
me.
All right, just you. That's fine. Hold on. Oh, there we go. Good.
There I am.
There you are. That's fine. Senator Waldstreicher on 78 for 3 minutes.
Thank you, Mr. Chairman. While the world is rightly transfixed by the trial of the murderer of George Floyd, like many of you, I was also deeply impacted by the murder of Elijah McClain. In the case of Mr. McClain, law enforcement requested that EMS administer a dose of ketamine, a powerful sedative. As passed, this bill is simply a reporting requirement for the use of ketamine. It begins in 2022 and sunsets automatically in 2024. This documentation is critical to allow us to determine if future policy action may be required. There is no cross-file for this bill. It passed unanimously in the Senate. I ask for a favorable report.
Are there questions for Senator Waldstreicher? Delegate Cardin.
Thank you, Mr. Chair. Just very quickly, I would support this bill very much. I was under the impression that ketamine is already illegal to administer to humans without a doctor's prescription, or I think it's even illegal with a doctor's prescription, is it not?
So that's not the case, Delegate. Thank you for asking. So ketamine is traditionally a sedative that's administered in a hospital setting. You are correct. But increasingly, EMS, including EMS in Maryland, is utilizing it on the street. In other words, with patients. EMS has a tough job, and these guys are experts. But of course, they're not doctors. And so we need to track the use of ketamine to determine if there's a problem with overuse or a concern about use at the request of law enforcement.
All right, Delegate McComas.
Thank you, Mr. Chair. This is for Senator Waldstreicher. Who was the gentleman that you referred to? Was he a Maryland citizen?
He was not. Mr. McClain was an incident that happened in Boulder, Colorado. He was a quirky kid. Someone thought he, for some reason, looked suspicious. I imagine you can guess why that might be. The police came to him and eventually called EMS, and requested adamantly that they use this ketamine under this diagnosis of excited delirium. As you know, as many of you know, or may have seen on 60 Minutes, the diagnosis of excited delirium is a controversial diagnosis, and all the more reason we need to track the use of this very powerful drug.
If I recall, this was the gentleman that would play music for the animals at the shelter. He was a violinist.
That's right.
Was he somewhat artistic or just, very private person?
I think that's a good, I can't diagnose, but I think that's a good description from my understanding.
So, and it was wintertime, right?
I don't know.
Well, I guess because wasn't the problem they gave him too much for his size, for his weight?
Well, yeah, there's no question. There were a lot of problems about the murder of Elijah McClain, and a long report and kind of a tangled series of bad mistakes that led to his death, some purposeful, some not. But part of that was the administration of ketamine. And as you indicate, part of it was they gave him enough ketamine for a person twice his weight and very much taller than he was.
Thank you. Thank you, Senator.
Thank you very much. Are there further questions for Senator Waldstreicher? Seeing none, we thank you very much. And that concludes testimony on House Bill 78. Going to Senate Bill 250 now. Senator Lee with two bills in a row. Yes, Senator Lee for Senate Bill 250, please. And it is just you, Senator Lee, because we've heard this in the past. So go ahead.
Yes. Thank you. SB 250 is cross-filed with HB 147. The bills are almost very similar. The committee just had two amendments. As you're well aware, Delegate Crutchfield and I introduced the bill to fully repeal the spousal defense law. Of course, because it's a bygone, brutal part of the code, created an absolute defense to certain sex crimes if you were married to your abuser. My esteemed colleagues, you all passed a bill as introduced, and the Senate Judicial Proceedings Committee, they had two amendments to this bill. One amendment struck the title of the bill. The other was an off-the-cuff attempt to clarify fourth-degree sexual offense as it pertains to the touching of an intimate area of another without consent. In order to understand this attempt to clarify the current law, we have to look at the existing law and legal interpretations of what is consent. I've included a 2020 advice letter from the Office of Attorney General on this point. There is a misnomer that consent requires permission for each and every touching. That simply is not the law, as Maryland's not an affirmative consent state. Mere passivity is not a consent to sexual touching. To prove lack of consent, a form of resistance is required. And this doesn't have to be physical resistance. Still, it does have to be a verbal no or similar objection of pulling away. In some cases, this is pretty easy to prove, like groping on the subway, for example. But other cases are particularly difficult, involving intimate partners, whether married or not, to figure out whether there is resistance and to prove a lack of consent. The court must look particularly to the facts of the case. And this includes the relationship of the parties. Just look at the AG's letter for greater details. JPR adopted an amendment that if you're in a sexual relationship, married or not, your right to consent and refuse sexual touching is different than if you are in an intimate relationship. Well, some view this as a clarification of the law, and while it does repeal the spousal defense to rape, the so-called clarification does create a new distinction in this committee. And so I asked the committee to examine this amendment closely, namely the fourth degree sexual. So I very much look forward to a conference committee on this important bill. I'm sure we can work this out to the extent necessary to clarify sex crimes or crimes, no matter what your marital status is, without cutting into the rights and protections against sexual abuse from any aggressor. So I respectfully ask my esteemed colleagues to please move SB 250 out swiftly, and so we can resolve any lingering concerns between the two chambers, the session. it's a long overdue repeal, and I ask favorable on 250 and hope we can work this out in conference.
Senator Lee, there are quite a few questions, so here we go.
Okay, go right ahead.
There's delegates Shetty, Erican, Williams, Grammer, Bartlett, and Cox, starting with Delegate Shetty.
Thank you, Mr. Chairman. And thank you, Senator Lee, for your incredible work on this bill. And another thank you to Delegate Crutchfield for her work on the House bill, which passed with an overwhelming vote of 125 to 4. I loved that version of the bill, in part because, you know, I think the prevailing purpose of the bill is to ensure that those who are married or in other intimate relationships are treated essentially the same when it comes to these types of crimes. And so allowing for this spousal defense really undercuts the purpose of our criminal law as it relates to sexual crimes. So I have a couple of questions I'd love to just kind of quickly ask you, please, Senator.
Certainly.
The amendment that you referenced. The amendment used a phrase, unless one of the individuals has reasonably indicated to the other that further physical contact is unwanted. Does this mean that some types of physical contact is never unreasonably wanted? Like, can you give us a little color? And then a second question before I yield is, the amendment also uses the term ongoing consensual sexual relationship. And I'm just wondering if this is defined anywhere, or is this supposed to be a factual issue?
No, it's not defined anywhere. And I think some members of the JPR committee were concerned as to what the definition of sexual conduct entailed. Currently, I believe there are two things. One is that there's defined by section 3-301, requires no consent, intentional touching, genital, anal, or other intimate area for sexual arousal or gratification or abuse of the party. And then there's a medical reason too, but it doesn't include common expression of familial or friendly affection. But the committee wanted just to clarify what was sexual contact under 4th degree sexual offense.
But then as a result, it's creating a different standard for.
Yes, it is.
Yeah, so I think that's really problematic. And I think it a little bit undercuts the purpose of the bill, which is not to repeal the spousal defense, but also to ensure that those who are in intimate relationships are treated the same as it relates to this section of criminal law. So I really appreciate your leadership on this, and I do.
Yeah, and I am
hoping we're able to conference on this.
Yes, thank you, Delegate Shetty, for raising that. I'm hoping that our conference committee can work out these concerns.
Thank you so much.
Delegate Erican.
Yeah, I would just echo the concerns that Delegate Shetty just raised. Some of those grotesque crimes against women happen inside of marriages. So we want to make sure that we're treating married women with as much respect as we're treating those who are not married. So thanks for your work on this, and I hope to see it in the conference committee.
Same here. Thank you, Delegate Erican. Thank you for your work too on child abuse cases.
So much excitement about conference committees. Wow. Delegate Williams.
Actually, you know what? Delegate Shetty kind of stole my thunder. The question, and it's okay. The questions she asked were the questions I was going to ask. I do have concerns, the same concerns as well. And so thank you so much, Senator Lee. And thank you to my colleague, Delegate Crutchfield, for bringing this really important piece of legislation. Thank you.
Thank you, Delegate Williams.
Delegate Bartlett.
Thank you. Thank you, Senator Lee, for bringing this bill. And I too look forward to the conference committee. I think Delegate Shetty did an excellent job of outlining the problems. Quick question. So I just want to make sure I understand. So I have two quick questions. So if you are married on January 15th, and on January 16th, if we don't repeal this law, if you're married on January 16th and let's just make it even better. Let's say you have waited to have sex until you're married. So you have waited to have sex until you're married. And so you get married on January 15th or whatever date you want to use. On January 16th, without this law, if your spouse treats you in a manner that is sexually aggressive, before this law and before we pass anything either way with respect to this law, you cannot claim spousal rape. Is that correct?
Yeah, that is correct. That is correct, Delegate Bartlett.
But if you did have sex with an individual on January 13th, it could have been rape.
That's correct.
Okay. Then the second thing I want to ask is, with an ongoing consensual sexual relationship, just to further up a little bit with what Delegate Shetty said, my question is, how long does this consensual sexual relationship need to last in this amendment? Because, you know, sometimes people have a habit of getting together, breaking up, getting together, breaking up. Sometimes this could last for 10 years, you know, you get together, you break up. And so at one point, perhaps one of the parties may say, I'm done. I am done with you. And with the law with the amendment, that ongoing or whatever was considered an ongoing sexual relationship over the past 10 years, if at any point in time, one of the parties says no, then that party would no longer be protected under the amendment that is currently before us with
No.
JPR.
Nope.
Okay. All right, thanks. I just wanted to get some
Thank you for
clarification.
bringing that up. Thank you, Delegate Bartlett.
Delegate Delegate Cox, then Delegate Crutchfield, then Delegate Grammer. Delegate Cox.
Thank you, Mr. Chair, and thank you, Senator Lee, for being here today. It's good to see you. I think as Delegate Shetty mentioned and Erican, and as the House vote indicated, there is a lot of support for the principle in this bill. And as you indicated, the concern is rather narrow to the fourth degree issue for those involved in a sexual relationship. And it's more of a clarity issue. It's not a second-class citizen issue, as has been, I think, inaccurately argued. I had a case where two individuals involved in a sexual relationship for years with children had a falling out, and a week before the falling out and the filing of custody and divorce and all that, there was an allegation made as part of a protective order that the one individual rolled away in the bed from the other individual. And that allegation, that mere allegation, was enough for a 1-year protective order, which was granted. Obviously, most judges will grant based upon a sworn statement. So I think the clarity language here simply is helpful in this amendment. And I would ask you this, when it says reasonably indicates, isn't that a kind of a clarifying, simple thing that somebody has to actually speak words to somebody, don't touch me? Isn't that reasonable? Isn't that the intent of this?
On that particular issue that you've highlighted, Delegate Cox, there was no hearing on that issue.
The amendment, there's what I'm not following.
There was not a hearing on that particular issue that we had on the amendment.
But it was adopted?
Was adopted. There were some concerns from some members of the
Right.
JPR.
But wouldn't you agree, though, that it's
They
reasonable?
wanted to clarify what sexual contact was.
Right. And wouldn't you
But,
agree?
Delegate Cox, why don't you, just in the interest of time, you might want to refer to the Office of Attorney General's letter for clarity.
But I'm just asking a reasonable question. Wouldn't you agree it's reasonable that someone would have to tell the other person that they don't want them to touch them? That's all I'm asking.
Well, you have to look to the facts as in any situation, prior behavior, current behavior, past behavior.
Okay.
The
Thank you.
trier of the facts, as you know, we're both lawyers, right?
Thank you very much.
Thank you, Delegate Cox. Delegate Grammer, you have a question?
Delegate Crutchfield, then Grammer.
Thank you, Mr. Chair. Thank you so much, Senator Lee, for working with me and for bringing this legislation. I truly appreciate it. I know that you fought vigorously against both of these amendments. And I don't want to belabor this any further. I do believe all my colleagues have really spoken up about their great concern with this legislation and that it's been amended. So I'm just going to leave it there and just say again, thank you. And we'll meet up at some point on this.
Thank you, Delegate Crutchfield, and thank you for your sponsorship and champion on this issue, and for all the committee members too. Thank you so much for putting so much thought and into this bill and moving it forward. And I look forward to working with you all on this. And
Members of the committee should be advised that conference committees are limited to 3 people. I think that's all the questions we have for Senator Lee on this bill. I think I called Delegate Grammer, but you lowered your hand. I'm just double checking.
All my questions are answered. Thank you.
All right. Thank
Delegate
you very much.
Grammer, good to see you again.
All right.
How you doing? Good to see you.
Good. We
All right.
worked on the strangulation bill last year.
Yes, ma'am.
All right. Thank you very much. Testimony for House Bill 250. We'll go to, I'm sorry, Senate Bill 250. We'll go to Senate Bill 623. Again.
Yeah. Okay.
Please.
I think this is an easier discussion, Mr. Chairman. Thank you for letting.
Well, we'll find out.
Okay. This is 623. It's almost identical to HB 425, which passed out unanimously out of this committee. And I appreciate the committee's hard work on this bill because it deals with ransomware. It's one of the most serious issues we have that can shut down, paralyze city governments, schools, infrastructure. So thank you so much. It's pretty identical. We only just had one amendment. It's like a clarifying amendment. Certain senators thought it would be helpful to clarify the exception that mirrored existing law for displaying obscene materials to protect non-criminal activity. The research exception is the one that I'm talking about, and the intent element were sufficient to protect researchers, but amendments provided by the Senate may ease concerns of cyber experts who test defenses to these attacks when they test the ransomware, to ask that the House Judiciary Committee pass SB 623 as it passed in the Senate, because we thought these were clarifying amendments so that we wouldn't entrap people that are legitimately testing ransomware to see if it works or not. Basically, I can tell you what the amendment does. Let me get that. We amended the original exception, which is the original exception is for research purposes. We amended it not to apply to a person who has a bona fide scientific, educational, governmental, news, or similar justification for possessing the ransomware. The exception mirrors, as I said, the language that applies to the child porn statutes to make sure that a person who has that bona fide reason for having the ransomware would not be penalized, and that this exception would clarify what testing and research is. So that's why we put that in there. As you know, this is a really important bill, especially with all the ransomware attacks that surge so much all over the country, but particularly in Maryland, that's been directed against like Baltimore City, where it shut down the city for weeks, cost them over $18 million to restore and get the data back. Some we think they never got back. They attacked the 911 dispatcher system. There was an attack against the Salisbury Police Department. I don't need to go on and on. You know all about it. It's like a weapon that is ready to be used. It's like a loaded gun with no possible defensive purpose. So I respectfully ask my esteemed colleagues to pass the Senate bill with the clarifying amendment.
Are there questions for Senator Lee on this bill? Seeing Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Senator. So who are the people that you're saying can have this ransomware?
If you got a bona fide reason to have it, like, scientists, it's an educational purpose, it's governmental, or perhaps, a journalist who writes, well, we had an example where there was a Bloomberg article and they wanted to test the ransomware, but you don't want to criminalize that behavior because it's for a bona fide reason.
What about if it's a person that has the ransomware that's trying to come up with something to block the ransomware, and they want to say that they actively
if it's for research, yeah.
Well, I mean, yeah, but yes, but do they have to be certified as a bona fide person that's doing? Do they have to be?
No, I don't believe.
So it could be an individual, but if they
no,
the reason that they're using the ransomware is to come up with their own disk or something to try to combat it, so they could sell disks, virus protection disks, that would be good enough.
Yeah, that would be considered like research or testing for bona fide research or testing purposes.
Okay.
So you don't want to get them caught up in this.
Right. Thank you.
That's why we use this exception.
That's why you're great. Thank you.
Thank you, Delegate.
Further questions? Thank you very much. That concludes testimony for Senator Lee's bill, Senate Bill 623. Let's go now to Senate Bill 105. Senator Sidnor, are you still there? You are. Senator Sidnor is here. This is workplace violence peace orders. I think it is sponsor only. It is. Senator Sidnor, please. Senate Bill 105.
Thank you, Mr. Chair, and good afternoon to the committee. If I might take the personal liberty just to welcome delegates Theon and Jones. I haven't had an opportunity to personally meet you all, but welcome to the best committee in the House. Flattery will get me everywhere, right, Mr. Chair? So,
yes,
you all are familiar with this bill. This is a cross file of HB 289, which your vice chair has been sponsoring for a number of years. There are two differences in this bill as it came out of JPR that I'd like to just focus your attention to. And that's in section 3-1502, section C. There was an amendment which states that there is no duty of the employer to file this petition order. And in section 3-1503, it deletes subsection E2, which removes an employer's civil liability immunity for not filing a petition. That's it. Otherwise, this is the bill that you all passed, and would ask that the committee move a favorable report on this bill.
Okay, we have questions for you. First from Delegate Juanita Fisher, then the Vice Chair.
Hi, Senator Sednor. Hopefully you can hear me okay. It's so good to see you.
You too.
Of course, I prefer my vice chair woman's version of this bill, of course. But I just had a brief question as to why or what the rationale was that you needed to clarify there was no duty of the employer to file it. And the reason why it does, I just want to know the rationale, because I am a little concerned, because the whole point is, how would then the employees file it if their employer does not want to for a threat? So if you could just talk a little bit about, I guess, the conversation and why these amendments were brought forth.
You know, this amendment was brought to me prior to the hearing, so I believe these are MAJ amendments. And I think MAJ wanted to ensure that, number one, that we just weren't doing any type of blanket immunity. So their thought was to strike that and the language dealing with ensuring that the employer didn't feel like they were, or it wasn't intended or noted that the employer had a duty to do so. I think they felt that that was the balanced way of doing this. So that was my understanding as to why the amendment was. Well, that's my understanding of the language behind the amendment. But again, it is your bill. I put it before you all, and say you do as you please.
Everybody's being too nice today. The Vice Chair.
Thank you, Mr. Chair. Always good to see you, Senator Sid. And I will say, because she checked me, she must not have a question, but it's Delegate Cham.
Damn, thank you.
Yes, because she did check me and I have not mispronounced it since. I just want
I
to thank
appreciate
you.
that.
I just want to thank you for taking up this bill when you cross the street. I really appreciate it. I don't know what we're going to do with the amendment. It is the trial lawyer's amendment, and it was summarily rejected over here. So see what to do. But I just wanted to give you my appreciation.
Thank you very much.
Everyone's so nice. They don't know what to do.
Senator Sidnor is a friend of the House. We love Senator Sidnor.
It's funny because where it was, you all were kind of tearing into some other members yesterday, but that's, you know.
Hey. Some can get.
Thank you all.
We're going to be nice. All right. I think that'll do. Senate, seeing no further questions, that's Senate Bill 105. Thank you very much, Senator
Thank you
for joining us today. We're going to go now, I think, to Senator Patterson. I see Senator Jackson. I don't know if I have there's Senator Patterson. We're going to hear Senator Patterson. Senate Bill 800, please. Senator Patterson, it is just you. Except you have to unmute yourself.
Okay.
That's better.
All right. Thank you, Mr. Chair, Madam Vice Chair, members of Judiciary Committee. I'm grateful to be before you again today to introduce Senate Bill 800 that I believe will be a life changer for many of our citizens, particularly those who are incarcerated with little or no pathway for sustained rehabilitation. Senate Bill 800 is before you as a result of my serving as a member of the Senate President's Work Group on Equity and Inclusion, with emphasis on Black and Brown Maryland. The state of Maryland ranks #1 in inmate lockups, and I might add rank #1 in total wealth. In 2019, there were 7,556 inmates locked up, and released, we had about 8,242 in that very same year. So Senate Bill 800 will focus on a coordinated and a specific step-by-step process of implementation to provide post-secondary education and technical training to inmates within 1 year of their being discharged. We've made the initial contact with all the key parties, Maryland Higher Education Commission, the 4 HBCUs have submitted letters. They're excited about getting on board and getting this program going. Correctional Center has some concerns, but we're taking care of those. Of course, we have nonprofits and other community groups who will be a part of this particular project. And finally, let me just say that, there are those who have been out in this market and working for a long while, and it is of the opinion of many that why that may be a small cost for this program, but we believe that within 2 or 3 years, this program will become self-sustaining. And I should tell you that as a former parole commissioner, I know firsthand about the lack of any type of rehabilitation techniques for many of these young folks. And I think putting in a program of this type would provide some hope, but also provide some meaningful skills so that they will become a little bit more marketable in terms of coming out looking for employment. And finally, let me just say, this is not a new topic to me. I've been around a little while. So in 2004, I did sponsor a similar bill. I got $3 million to do it. And it was very successful program. So I know the way, and I just asked that this committee look favorable upon Senate Bill 800. Thank you very much.
Thank you. Thank you very much. Are there questions for Senator Patterson? Delegate Juanita Fisher, please.
Oh,
Hi, Senator. How are you? It's so good to see you.
hello.
I just had a question, and you may have said it, and I just got distracted. What was the breakdown on the vote for your bill? Was it bipartisan? Was it?
It was unanimously, there was unanimous, I was 100% in favor of this.
100%. Okay, thank you.
Also, there were no opposition. We had at least 15 to 20 folks who did testify.
Thank you, Senator.
Sure.
All right. Any further questions? Seeing none, we thank you very much, Senator, for being with us today. And that concludes the testimony for Senate Bill 800. We're now going to go to Senate Bill 606.
Thank you.
Senator Jackson, harm to service animals, the Cross Delegate Williams bill. We heard that an eternity ago.
Yes. Thank
Senator Jackson.
Mr. Chairman, Madam Vice Chair, members of the Judiciary Committee, it's a pleasure to testify before you today. The bill you are very familiar with. You're familiar with the cross file, House Bill 234. I'd like to thank Delegate Williams for having me be her Senate cross file. The bill before you has amendments from the House, from the Judicial Proceedings Committee. The amendment number 628-675, under amendment number 1, the Judicial Proceedings Committee struck intentionally and recklessly killing and left killing or injuring, and also struck requiring the court to order a certain defendant to pay, and inserted authorizing. JPR also reduced the penalties from $5,000 fine to $2,500 fine, and the imprisonment not to exceed from 5 years to 2 years. So having said that, I'm sorry, there's also one more. We also struck the committee also had could not define interference of a service animal. So that was struck as well. But having said that, Mr. Chair, Madam Vice Chair, and obviously to the initial sponsor of the bill, it is the wish of this committee. It's your bill. I'm honored to have carried it over in the Senate for you. Just for the record, JPR voted the bill out as amended 11-0, and the Senate passed it 47-0. And I know that your committee passed it out with your amendments 17-2, and then the House 131-2. I asked for a favorable, love to see the bill pass, say a valuable piece of legislation, and it's up to you. Thank you, sir.
Thank you. Are there any questions for Senator Jackson? Seeing none, we thank you very, very much. And that concludes the testimony on Senate Bill.
Thank you. Have a great day.
607. I would ask the committee, we are just going to take a very brief break, and then we're going to come back for a voting session. So if staff could put on quickly, if you need to take a step away, we will have our voting session begin at 2:45. 2:45 this afternoon, we will begin our voting session. Thank you all very much. And that was our final bill hearing witness. We've heard this year 1,990 witnesses as the House Judiciary Committee. So quite a few. All right. Thank you all very much. We will stay and keep this live. This will be live. If you need to step away for a few minutes, go ahead. But plan on being back in 7 minutes at 2:45. Thank you.
We have to go to another stream.
I'm sorry. We're going to have to go to another stream. So 2:45, we will be voting.